Welcome to the Kickin Show, everyone. It's the official podcast of Kickin the Tires, and it's an impromptu show. We haven't done one of these in a long time, but today I have a special guest he is an expert in antitrust law. Go figure. I would have an expert in antitrust law when we've got the 2311 and Front Row Motorsports versus NASCAR lawsuit going on in Charlotte. So his name is Danny Karon, Professor Danny Karon. Welcome to the show, and tell us a little bit about yourself.
It is a pleasure to be here with you guys. Thanks for having me. Yes, I teach consumer law and class actions at University of Michigan and the Ohio State University. I began teaching at Columbia Law School, and I practice a lot of antitrust. I also have my own firm, of course. I still practice. That's where the antitrust comes from. It's a lot of price fixing cases, but Michael Jordan's case. It's a Sherman Act case, no different than the Sherman Act cases that I sue every day. So we can talk plenty about it and what all's going on and why it's here, what we expect to happen, and how the trial's going.
So I guess antitrust is it's an area of law that probably there's not a whole lot of lawyers that really specialize in this. So you probably know everybody involved.
Yeah, it's a little specialized. The Winston and Strawn lawyers, the lawyers that Michael Jordan hired to file this case. Yeah, I know some of them. We're up against them all the time. I think we're probably in a few cases with them right now, if I had to guess. So yeah, we all tend to know each other to some degree or another. Yeah.
So what is this case? How's it playing out? I mean, it is from the very start. I mean, the filings were very contentious, calling NASCAR a bully and a monopoly, and now it's devolved into the judges admonished them last week about their conduct in court and doing things that are. So I'm going to let you kind of take us through everything from your perspective, from a professional perspective. But what set up this lawsuit and what you think from the start is how it is playing out for you after a week of testimony from witnesses.
It's a case involving competition. I mean, you might think of a lawsuit as something involving an auto accident at a corner or breach of contract. This involves competition. That's what the Sherman Antitrust Act is intended to address. And that's what this case involves, is a couple of Sherman Act claims. What's the alleged um, 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 offense here as it concerns NASCAR? Well, we hear the word monopoly thrown around a lot. A monopolist is a single firm or single company that has market power, meaning it's the only game in town, so to speak, and they can decide what they're going to usually charge people to buy their product. They overcharge because there's no competition. That's actually not what this case is. This is a monopsony case. A monopsony is the opposite of a monopoly. A monopsony is when you've got not one seller, but rather one buyer. You've got NASCAR saying, hey, we're the only game in town. We're going to underpay you rather than overcharge you for the whole charter system and participating in our market for stock car racing because we're the only game in town. So if you don't play by our rules, you're going to be out of the game. There's nowhere else you can go. So that's basically what this case is about. Lack of competition in terms of other tracks, other circuits like Tony Stewart's circuit that shut down, or the ability to get a better deal because of that, because there's nowhere else to go. So if you want to race, you're buying into what Mr. France tells you, and you're taking a lower price. You don't have any real team security, meaning you might not have a charter come next cycle, might not be able to show up and race your cars, and the payouts are low. So it's a whole mess that concerns competition, or better put, lack of competition concerning NASCAR.
So, we've heard different things happen. Scott Prime got up there and said he didn't know anything about what was going on in with how the teams were shaping up and the documents that were put together. And he's paid $400,000 a year. And how does all this type of stuff play out when you've got your executives saying they don't know what's really going on and they just are paper pushers?
You get a lot of that in these cases, whether it's an antitrust case or a regular business type case where people feign ignorance. Maybe they don't know. If they don't know, they should have known. They're held to have had a duty to know. It all goes to what the jury makes of it, deciding the credibility of the folks on the stand. And if they think, hey, either he's a liar or if he doesn't know, he should have known, neither is a good outcome for NASCAR. Now, the jury might also figure, hey, this is completely plausible. He shouldn't have known. Maybe there's no liability here for NASCAR at all. Maybe there's no abuse of monopoly power, which is what the jury question now is. It's not whether there was a monopoly. That was count one, that Michael Jordan and his team won on summary judgment. But now it's a question of whether NASCAR abused in that monopoly power. And the jury's going to decide based on what they hear from witnesses and what they see in documents.
And when you, in this case, there's six jurors. What in a criminal case, you have to have beyond a reasonable doubt. This is a preponderance of evidence. How does that work in a mindset for the everyday person?
It's a big difference. So we're all familiar with beyond a reasonable doubt from, say, Law and Order. You've got a jury of 12 in the box, and beyond a reasonable doubt means, for instance, let's say you have a scales of justice, and the prosecution in a criminal case, which this isn't, in a criminal case has to prove or has the burden of proving its case beyond a reasonable doubt, meaning all the way. I mean, basically, so super convincing. There's no scintilla to speak of evidence suggesting that there might be innocence here. That's a very heavy burden. And as well, it should be because the consequences of a criminal case are often so extreme. Well, that's not what we have here. We have a civil case. And the standard of proof isn't beyond a reasonable doubt. Rather, it's by a preponderance of the evidence, which simply means Michael Jordan's team has to prove its case by just a little bit more than half. Like not, 99%, but 51%. If the jury feels to a 51% degree that there's legal liability here, meaning NASCAR abused its monopoly power, then the plaintiff, Michael Jordan, wins. It's a much, much, much different than in a criminal case involving beyond a reasonable doubt.
So you brought up SRX series. Tony Stewart series is no longer around that NASCAR put into text messages that they wanted to kill it, quash it, put a knife in it, whatever their wording was. First off, why do people continue to put stupid stuff in writing? I mean, what is with this? It's going to get in, if they ever get sued, it's going to end up in discovery.
Boy, that's the thing. Like, if people didn't act stupidly and put stupid stuff in writing, I'd never be able to prove any case. People do it all the time because they don't have a legal mindset. They're not thinking in a kind of proactive, forward-looking way. They're just kind of thinking in real time. They're thinking, maybe it'll get buried. Maybe no one will see it. They don't think about the legal consequences associated with it. Happens all the time in every one of my cases because in these business cases, again, it's not like an auto case where your proof is going to be the photos, some witness testimony, the police report, those sorts of things. Here, there's no snapshot of what happened. What happened evolved over time. So it's in documents and testimony, and it's usually in documents, as in millions and millions of pages in most of my cases. We've got to go through them all and figure out what the heck happened. And when you find a smoking gun, like what we're just talking about, that's good stuff. You hold that up, that's exhibit one, and often that turns the case.
How do you think that will play out with the jury? If you were prosecuting this case, how would you play that? That they're trying to kill this series because they think it's competition. That's exactly what Michael Jordan and them are alleging.
That's a good exhibit. That could be exhibit one. Juries, indeed, people don't like bullies. They like fair play. They like fairness. They like people getting a fair shake. They like innovation. Like they like people getting to the top through hard work, not through misdeeds and dirty deeds and underhanded stuff like we're talking about or what's alleged to have happened here. I don't think that exhibit and similar ones are going to play well at all with the jury. That said, it depends on the jury. I mean, if you got a jury of six, big time, corporate types, big companies, NASCAR fans, but they're employed by banks or insurance companies. I mean, we're stereotyping a little bit, but we do that when we pick jurors because you have to try to get a feel for what these folks um, dispositions or predispositions might be. So I don't know what the jury's like. I wasn't sitting through voir dire, but I would think as a matter of common sense and good form and good judgment, that sort of evidence is not going to land well with anybody.
I was shocked that they picked a jury within a few hours. I mean, that was crazy.
You know what? It just depends. Sometimes you got a judge who wants to move the case, you're going to get it done. You got a judge who wants to do questionnaires and let this thing, go for a couple of weeks. Well, a couple of weeks is pretty extreme. Maybe a week or so to pick a jury. That does not portend well for the rest of the trial. It's going to be a long, long trial. But what were they projecting? Like maybe I think 2 weeks for this thing, which would include voir dire. It's moving, and we're heading into week two. So depending on how long deliberations take, we could have a verdict by end of next week, beginning of the week, end of this week, rather, beginning of the week following.
Well, there's been some talk that because the judge had actually admonished both sides and say, look, we're not going 3 weeks with this. The jury will revolt.
Mhm.
So you got, because that gets into like Christmas and stuff. So he told him, you got to wrap this up. You got to speed this up. And I think we went a little bit longer than some thought. There's still some witnesses coming back. There's some key witnesses coming in, like Roger Penske,
Mhm.
Richard Childress. But Michael Jordan's already testified, and he got up there and he's like, "Look, I had the money to fight NASCAR. That's why I'm doing this because it needs to be fair." Does the fact that NASCAR has less money than Michael Jordan mean anything in this? I mean, I have played it out in several other podcasts that I've been a guest on. When you've got no cares in the world and you're doing stuff on principle, it's kind of like, so what? However it plays out, it plays out.
It shouldn't matter. I mean, technically, strictly speaking, it should not matter that Michael Jordan, even though he's alleging he's the victim, has more money than the bullies. It shouldn't matter at all. And what I found in the cases I've tried, I've actually been on a jury too, is that juries are principled too, and they get it. And as much as they, grouse and crab about making it onto the jury and taking 2 weeks out of their lives or whatever, once they're on it, I mean, I've seen everybody dig in and become very, very serious about it because next to military service and voting, jury duty is our most sanctified constitutional right. And those who get it, and most jurors do, take it very seriously. So the fact that NASCAR easily has less money than Michael Jordan, I don't think should, and I don't think will make any bit of difference. Now, Michael Jordan, for his part, why is he doing this? He's so loaded, right? Well, because he is principled, because it's not right. He is one of only two charters who refused to sign the last agreement and said, we're not going to deal with this. We're not going to do it. In fact, we're afraid that if we sign this thing, there's a waiver that wouldn't allow us to sue an antitrust case. So they backed off, didn't sign. That front row is the other one, obviously, his co-plaintiff, and then went, of course, to the court to ask for an injunction, which is to say, hey, judge, could we have an order that allows us to compete this season? Because if we don't, because the trial's going to take some time and so too is discovery, we're going to be out a year's worth of revenue, and that's just going to compound the problem. And the judge actually awarded the injunction, which was reversed by the Fourth Circuit. So, Michael Jordan and Front Row are kind of out of business until they, if it's we're up to them, that is, win this trial. And if they don't, then of course things proceed as they are, and they'd be an open participant, if anything, and they're going to have to decide what they want to do. But time will tell. Not much more time. What's going to happen?
So when you see things like what they said about Richard Childress, that text message apparently at this point is not going to be introduced because it's prejudiciary.
Prejudicial under Rule
Prejudicial.
403.
Yeah.
Yes. Mhm.
Explain that because I would think that you, you know that's important in a case like this of what you think about the people involved and how you treat them and how it could have played out in some of the decisions you make in what you're doing as the sanctioning body of the sport.
Yeah, not all relevant evidence is admissible. If it's unduly prejudicial, there's a balancing test the judge conducts under Federal Rule of Evidence 403. And if he or she decides that it's unnecessarily or unduly prejudicial, despite its relevance, it can be kept out. All I can surmise from that is that maybe it's because there was already a ruling that NASCAR was conducting a monopoly, and that evidence went toward monopolization rather than abuse of the monopoly power. Maybe that's why it wasn't deemed necessary for admissibility. Rather, it was deemed unduly prejudicial, which would only piss off the jury. I mean, plaintiff's counsel would tell you, oh, it's absolutely relevant, when in the back of their mind, if not the front of their mind, they know it's intended to piss off the jury. The judge has to make sense of all that and make a decision.
And there's still a chance that it could come in. So I don't know if you were following it on Friday or not, but apparently NASCAR used some stuff that the judge said you're not allowed to use, and he jumped on them after court once the jury had left the room and said, "I told you we're not going to have this. You're not going to do this." So if one of NASCAR's witnesses, or if Richard Childress or somebody, if NASCAR opens the door, so to
Yep.
speak, it still could come in, and as you said, it would definitely piss off the jury.
That's right. If they open the door, that changes the ball game potentially, and maybe that allows that evidence to come in for rebuttal. So we'll have to see. I mean, if plaintiffs make a pitch, introducing that evidence again on account of door opening, that's a different argument. That's not so much as, it's relevant and then there's a prejudicial, calculus to consider, but rather it's to set the record straight. It's in rebuttal, not in our case in chief. And the Judge Bell will have to decide.
Another witness that testified last week was Heather Gibbs, and she talked
Mhm.
about begging NASCAR to not do this. So explained their business model and what they've done, and that this is all they have basically, and NASCAR didn't care. And and it's like you're using this as a weapon. We have to sign this because we have no other way to conduct business. If we don't sign it, we're out of business, and you're
Right, didn't
forcing
care.
us to do
Yeah,
that.
didn't care. They gave him an hour.
Yeah.
They said you got an hour to sign it. Enough is enough. We're not going to bargain with you collectively. We're done. And then, as a matter of good form, they gave him till midnight, and that's when Michael Jordan in front row said, "To hell with this. We're not going to sign it, regardless how much time we have." But you're right. I mean, that was the whole holding the gun to the head analogy. They said, you're going to sign this thing. You're going to take cheap money. You're going to only compete in our network because there's nobody else out there. We've, shut the rest of them down. We've either bought them up or shut them down. And we're basically going to run the table. And the teams had to decide whether they wanted to hold tough, like Michael Jordan in front row did, or capitulate and move, forward under NASCAR's new charter rules. One of which, like I mentioned earlier, is a waiver of any antitrust, arguable waiver of any antitrust claim. So Michael Jordan not only didn't want to buy into this business model, but he didn't want to face an argument that, hey, I can't sue you for it because I've waived that right by signing the charter. So there's a lot going on a lot of different levels. And Michael Jordan had the money and the good form and the principle to stand up and say, I'm going to, try to do what's right, not just for my own good, but if you take a look at the relief that he and Front Row are seeking, it's for the good of the other charter owners.
So when you have a clause in a document and that you're requiring people to sign, and it says you can't sue us if we're a monopoly, isn't that an admission that we're a monopoly or a monopsony or whatever?
No, it's just a liability waiver. I actually discussed that. I have a book that it was just released. It's called Your Lovable Lawyer's Guide to Legal Wellness, Fighting Back Against a World That's Out to Cheat You. And it's all about legal wellness. It's about getting out of legal problems for everyday folks or avoiding them to begin with, because a lot of us don't have any real aptitude for or awareness of or familiarity with the law because we're just not taught it in the same ways we're taught, say, how to manage our physical wellness or our emotional wellness or our financial wellness. But legal, no, you got to hire an expensive lawyer. And I wanted to give those tips and techniques and tactics up to folks in kind of a DIY law degree so people would have a resource to protect themselves when these sorts of issues came down the pike. And one of the chapters goes straight to this: liability releases and waivers, and whether they're enforceable and what they say, what they mean, and how people should have their eyes open for them, not just in this context, but every other context, whether it's signing up to join a health club or buying a product or anything, they're everywhere. And to your question, does the mere existence of one suggest that the person who had you sign it has done something wrong? No, of course not. Maybe they do nothing wrong and they never invoke the clause. But if they do something wrong and they were to be sued and they were to be found not liable, that would have meant they did nothing wrong. They just don't want to get sued at all because it takes time, it takes money. You pay for lawyers, like, you know what, to hell with it. We'll just snuff that out. You can't sue us at all. And you look to state law to decide whether, or federal law in this case, whether liability waivers are enforceable or not. Sometimes they're not, like as a matter of public policy, they're just deemed unenforceable, like let's say you're in the health club example. Um, you join a health club and you're tying your shoe in the locker door, comes off the hinges and falls on your head and gives you a concussion. And you want to sue the health club. But the health club defends on the basis that, hey, listen, your health club contract has a liability waiver. This is, you can't sue us for anything related to our negligence. Some courts will say, hey, it's in there, you signed it. And some will say, who reads this stuff? As a matter of public policy, we're not going to enforce it. Here, however, where both sides are represented by competent counsel, it's probably going to be enforceable unless that is you have no choice because it's a monopoly. So that's where your play is. Which issue is a non-issue here because Michael Jordan never signed the thing to begin with, so there's no liability waiver.
So how does it play out when they go to the racetracks and they tell Marcus Smith, you have to sign a document to race with us, and that you're not going to let another stock car group come in that we don't approve of because that's competition.
Oh yeah, that's the exclusive dealing clause, we'll call it. That's part of the argument Michael Jordan and Furrow are making too, is that they locked up all the tracks and said, hey, listen, you can't have like a Live Golf come in, and do a separate tour that's going to compete with us. That is it is super ugly, but you know what? It's in there. So one of the elements of damage or relief that plaintiffs are seeking is to undo that. They not only want their money back for their lost profits, trebled, meaning tripled plus attorney's fees, because that's what the Sherman Act, actually, the Clayton Act is what creates the private right of action for a Sherman Act violation. That's what the Clayton Act gives you, but also for injunctive relief, kind of like the injunctive relief we talked about earlier, where they said, hey, we want to compete, which injunction was undone by the Fourth Circuit, but they want a lot of institutional or structural changes made or ordered by the judge as a consequence of a, hopefully for their part, a plaintiff's verdict.
So when we break it all down, and NASCAR is going to start putting their case on next week.
Hmm.
If you had to give a score after 5 days, where do you see this sitting right now? Who's winning at this point in the game?
Oh, plaintiffs are always winning after their case in chief's done. I mean, it's just you can't look at, half the script. You got to look at the whole thing and assess it at the end. I mean, that's why the judge, would tell the jury, of course, hey, listen, you can't, reach a conclusion until you hear all the evidence because were you to hear one side, it's like when I get into a fight with my wife, you hear her argument, you think I'm always wrong. Hear my argument, you still think I'm always wrong. But anyway, you got to wait till it all comes in. And how it's going to go, I'm sure NASCAR's lawyers are going to do a bang up job, but then the jury takes over, and that's the way our system works.
How do you play this if you're NASCAR's lawyers? How do you defend a sanctioning body that has done so many things? And look, I'm not gonna lie, they've done things to media. If you write a negative story that they don't like, they'll give you a phone call and say, "Hey, we don't like that," and that could you might. I'm not saying they'll do it. It's happened to some people that I've
Sure.
talked to, but do you get less parking? Do you get
Oh, yeah.
not favorable credentials or a seat in the media center? If you had a seat in the media center for 15 years and all of a sudden you get moved because you may have made someone mad. I mean, there's actions that NASCAR takes. They fine teams. They penalize them in the garage. So there are things that have happened. So how do you put on your case when that type of stuff comes out in court?
Well, I read in the complaint too that t charter owners are concerned about getting calls, and they were uh, helping develop the plaintiff's case on condition of anonymity because they didn't want to be named, obviously. But everybody knows what's happening out there, and the documents presumably don't lie. How do you defend against that? Presumably there's a good defense. If there weren't a good defense, they would have settled. I mean, they went to two mediations and they failed. So NASCAR thinks it's got something up its sleeve, some ace in the hole, some bird in the hand, some who the heck knows what. I've not seen anything that that convinces me or that's compelling, I should say, to suggest the absence of market of abusive monopoly power. But we're going to find out pretty quick what their defense involves.
Could it be that Jim France is just that dug in and he's like, "Mm, this has been in my family since the beginning. We've done it this way. It's our way or no way. If you don't like it, we'll destroy it and we'll take our money and go retire in Daytona Beach."
Could be. I don't know. I'm not in his head. I mean, ego plays in, but it's also a business. It's a business decision come end of the day. I've had a lot of defendants defend based on ego, but come end of the day, they talk to their lawyers and reason prevails and they want to get the case behind them because the consequences are too dire. I mean, consider again what Michael Jordan and Front Row are asking for. Not only their economic damage is associated with bad charter deals and being out for some part of this season, times three plus the attorneys. And there, let me tell you, if you look at the complaint, there are like 5 or 6 lawyers on there, maybe 5 lawyers, and they're not cheap at that firm. Believe me, they're not cheap because they're good. And the structural changes that they're demanding, which could open the league up to competition. I mean, if they were to settle, they probably wouldn't have to worry about opening it up to competition unless that is somebody sued them and alleged that they wanted competition to be allowed. But they are playing some high stakes poker here. And why? I can't imagine how it's going to turn out. I don't know, but that's the game, that's the system, that's the process, and we're going to find out pretty soon.
If 2311 and Front Row Motorsports win, how does that impact the charter teams that sign the contract? Do they get the beneficiary? Because again, those teams, many of those owners said, look, we had no choice.
Yeah, injunctive relief often benefits unnamed parties. So, for instance, um, let's say you've got a chemical plant that's chugging toxic fumes and polluting groundwater of an adjacent neighborhood. And one of the residents sues to enjoin them from continuing to do that. Maybe put on filters or something, and wins, and then the power plant, takes those steps and the pollution stops. Well, the other neighbors necessarily benefit from that behavior without having even shown up in the case or a trial. So there's the potential for that to happen here too. Namely, the other charter owners would get some beneficial pop from a positive or favorable plaintiff's verdict for Michael Jordan in front row.
When you look at this case and 10,000 foot view, how do you see it at this point and then going into next week? Do we get a jury? I mean, you're not in their head, but do we get a jury that it looks like, hey, NASCAR's going to have to do something? I guess the judge has to decide what remedy is. The jury just decides if they're guilty, for lack of a better term, but that's not the correct legal term.
Liable,
Liable.
liable. I can't know how it's going to turn out. I mean, if believe what if I know it's going to turn out, I wouldn't be in this business. I'd be in something else, making a lot more money. But it's just it's high stakes and it's
But
scary.
you've
I mean,
done
I've
this,
tried
so you
cases.
you kind of you might
Yeah.
have an idea from watching.
Well,
You have more
yeah,
experience than me.
I'm familiar with the plaintiff's case in chief, and it was good stuff. I'm familiar with the documents. I'm familiar with the allegations in the complaint. I'm not yet familiar with the defense. I wasn't at the mediation. None of us were was. I don't know what's going to happen when the defense puts on its case because they haven't done it yet. So none of us can know. But if we get together after that and talk about how it all went in, it's going to be a much more even-handed conversation. On the other hand, it could be like, I can't believe they spent a week putting in that garbage. That was their case in chief. This is going to be a walkover. That said, I've seen plenty of sure things crumble too. You just never know. And that's why it's really tough. I mean, I know what you want me to say. You want a prediction, and I necessarily can't do it. Nobody could.
Okay, let's play hypothetical. If
Okay.
if
All right. You can try again.
2311 front row, no, I don't need an answer, but if 2311 front row win, what is the remedy that the judge would likely take? Likewise, if NASCAR wins, then what happens to 2311 in front row?
Sure. If plaintiffs win, the remedy sought is, of course, money damages, lost profits, trebled attorney's fees, and structural changes, as in much more fair treatment of the charters and changing the whole system in terms of interaction with the charter teams. How that's going to shake out specifically, nobody can know yet, but that's where it's going, obviously. And then enhancing competition, of course, maybe loosening up the grip on the speedways and other teams trying to compete. I don't know who's out there waiting in the wings in the event of a plaintiff's verdict, but if the plaintiffs win, I suspect there'll be some competitors who want to jump all over it. That's if the plaintiffs win. The defendants win, status quo. They tried, plaintiffs did, and they lost. And Michael Jordan and Front Row don't get their money back. Their lawyers don't get paid. Well, they're getting paid per hour, I'm sure, anyway, but I can't know. I suspect they are, but they won't be. Michael Jordan won't be reimbursed for their fees, that is. And the structural changes sought both internally and externally won't happen because the jury will have found that they didn't abuse their monopoly power. So why should they have to change anything? That's kind of how it works.
Is there anything in this that I have missed as we start to wrap up here? And I appreciate your time. And it's a Sunday afternoon. And I know you've got family. I'll cut you loose. But is there anything I missed? Is there anything that's key for the viewers here to know what this case is about and what they need to watch for?
I think we've talked about what it's about, but I just think it's worth reemphasizing how important it is to keep an open mind. And as much as your listeners would love for things to end today with plaintiff's case in chief having been the only evidence proffered and the jury being able to decide based on that, there's going to be a week or so of testimony to watch closely, and there are going to be stories coming out every day, and people's expectations might go up and down and be a little deflated or maybe be elevated based on a good cross-examination or some killer document that they didn't appreciate the significance of comes out and bolsters the defendant's case, and then it goes to the jury if it doesn't settle, that is. And then everyone's on pins and needles. And you wait and you wait and you wait. And there's always this conjecture. Okay, the jury comes back quick. What does that mean? Oh, it means it was a no-brainer. They find liability. Or no, if they come back quick, it means there's a no-brainer. They found none. I mean, you just can't know. But we all have to wait. And waiting on a jury is like Worst thing ever. But, again, it's part of the system. So that's what's right now, absent a settlement, that's what's in store.
I have said since the beginning of this case, I actually told one of NASCAR's executives that I trust highly, um, you guys need to settle this because it's bad for the sport. It's bad for fans that want you to lose. It's bad for fans that want you to win because it's ripping NASCAR apart as a sport. So is this something that they probably should have settled?
I'm glad you raised that because often we think, hey, listen, the publicity is bad. It's bad for the sport, bad for the industry, bad for the company, bad optics, all that stuff, bad for advertising revenue, all that stuff, right? And that's what you're getting at. But I'm working on a case right now, and it's against a big company that has a big local presence in a certain market. And they couldn't care less. I mean, and even boiling it down to kind of an individual case. I worked on just a really grisly sex related case, and I thought this family wouldn't want anything to emerge related to it, and it did. And that case was in suit for a long time. So my point is that you can't put too much stock in or evaluate or judge somebody else's temperature for publicity or discomfort because you just never know how that's going to compare to their hubris, their ego, their self confidence, their disregard for all that. I mean, you just never know. So it's easy to say, hey, they should have settled this because the allegations are so ugly. Often that happens. But as we're seeing in this case, it hasn't.
Well, excellent, Danny. You know what? Maybe we can get you back on when the case is over, and we'll do another podcast with you, and you can break it all down from after we have all of the information of
Yep.
both sides.
We're just
And
halfway in.
excellent. I will give you a holler. Thank you for joining us. I appreciate it, and best of luck to you and your cases as well.